Polity and governance. First topic, reform in 7th schedule. 7th schedule under Article 246 provides distribution of powers and responsibilities between the state and the central governments. It specifies the role and responsibilities into three lists, namely union list, state list and concurrent list. The union list details the subject on which parliament may make laws, while the state list details those under the purview of state legislature. The concurrent list has the subject in which both the parliament and the state legislature have jurisdiction. However, the constitution provides federal supremacy to parliament on concurrent list items in case of a conflict. Article 248 confers residuary power on the parliament. Residuary power refer to the power of jurisdiction upon subjects that are not mentioned in the state or concurrent list. As per Sarkaria Commission, concurrent list subjects are neither exclusively of national concern nor of local concern and hence occupy a constitutional grey area. Let us know about the evolution of 7th schedule. In Indian Council Act 1861 brought Provincial Legislature Council which had substantial Indian representation. Lord Ripon's resolution in 1882 introduced elected municipal councils and rural district boards. Government of India Act 1909 empowered provincial councils enabling more Indian representation. Government of India Act 1919 relaxed central control over provinces by demarcating and separating central and provincial subjects. Government of India 1935 laid down the scheme of distribution of legislative powers into three lists, which has been retained in Indian Constitution. List 1, the Union List at present. List 1, the Union List over which the Parliament has exclusive competition includes defense, foreign affairs, railway, banking, etc. There are 100 items in Union List. List 2, the State List over which the state legislature have exclusive competences. It includes public order, police, public health and sanitation, betting and gambling, etc. 61 items are numbered in this list. List 3, the concurrent list over which both the parliament and the state legislature have competence. Education, population control and family planning, criminal law, protection of wildlife and animals, forestry, etc. are present in this list. 52 items are there in concurrent list. Rationale of keeping 7th schedule in the constitution. Ensuring unity and integrity of India. Due to the partition, there was an emphasis on national integration, and only a strong central government could manage the complex administrative problems, protect the nation against external threats and invasion, and maintain international relations, enabling responsive governance. Local governments under the state list are seen as the encouraging political participation, accommodation of various views, bolster rights of minorities and communitarian values. It engages the public policy making, its implementation, monitoring and evaluation. Achieving balanced economic development. 7th schedule favors the allocation of legislative power to the union government and to ensure economic development at the national level in a coordinate manner and bring parity in socio-economic development across states. Promoting diversity. Allocation of legislative powers to the state can promote cultural autonomy given the unique diversity in India with respect to its geographical area, population and number of languages spoken. As per Joint Committee Report 1934, it was necessary to ensure that provinces remained truly autonomous to determine their jurisdiction independently in order to bolster spirit of cooperation between union and the states. Need of revisit Schedule. The present 7th schedule contains union, state and concurrent list were inherited from the Government of India Act 1935 and needs to be updated with the changing time. Citizens increasingly demand efficient delivery of public goods but without delegation of funds, functions and functionaries presently dominated by the central government, local government and are unable to respond. Items have moved from the state list to the concurrent list and from the concurrent list to the union list, highlighting centralization in the era of decentralization. For example, shifting of the subject like forest and education from the state to the concurrent list by the 42nd Amendment. Dominant position of center. In concurrent list, central law prevails in case of conflict between state and the central law. Central law effectively giving central dominance in concurrent list as well, ensuring that existing entries are or new entries that are sought to be added are appropriately placed under the three lists, highlighting the needs of the governance in 21st century. Central state conflict. Federal tensions in post independent India, such as state demand for greater autonomy, further highlight the need for reforming the 7th schedule. Procedure for the amending 7th schedule. It can be amended as provided under Article 368 in Part 20 of Constitution. It requires special majority of the Parliament, that is majority of the total membership of the House and by the majority of not less than 2/3 of the members of the House present and voting, and also the consent of half of the state legislature by a simple majority. Other provisions that can be amended in such manner are election of president and its manner, extent of the executive power of the union and the states, Supreme Court and High Court. Way forward. Constitute a high-powered commission. It may consist of eminent lawyers and jurists with administrative experiences to examine the entries of List 1 and List 3 in the 7th schedule and suggest redistribution of the entries. Institutional framework. Consideration for a consultative forum for credible policy dialogue between the center and the state to give a boost to cooperative federalism. Sarkaria Committee recommendation in 1998 report. Restitutory power. Restitutory power be transferred from the union list to the concurrent list except for the restitutory power to impose taxes which should be retained in the union list. Concurrent list. State should be consulted by the center before exercising power over concurrent list. Periodic review. Undertake a periodic review of the list focusing on removal of outdated entries, addition of new entries and appropriate placement of existing entries. Transfer of entries. As per Punchi Commission 2010, center should only transfer those subject to concurrent list which are necessary for ensuring uniformity in basic issue of national policy. Next topic, death penalty or capital punishment. Recently, the Supreme Court had so moto opened a review of the process by which courts award the death penalty. Death penalty, also known as capital punishment, can be defined as a practice sanctioned by the law whereby a person is put to death by the state as a punishment for a crime against a proper legal trial, used as the mode of punishment since time immemorial. The moral acceptability of death penalty, that is state power to execute people and its circumstances in the matter of debate globally. Death penalty in India and its framework. India is among the few countries to retain capital punishment under different laws for various offences beyond the Law Commission recommendations. Article 21. No person shall be deprived of his life or personal liberty except according to procedure established by law. Also under the 7th schedule, criminal law and criminal procedure are under concurrent list, leading to various laws dealing with the death penalty such as Indian Penal Code 1860, Narcotic Drugs and Psychotropic Substances NDPS Act 1988, Arms Act 1950, Air Force Act 1950 and Navy Act 1956, Commission of Sati Prevention Act 1987, SC/ST Prevention of Atrocities Act 1989. International conventions. Being the irreversible nature, death penalty is opposed by UN and its agencies such as Second Optional Protocol to the International Covenant on Civil and Political Rights, that is ICCPR, Convention on the Rights of the Child, CRC, 4 UN General Assembly resolutions since 2007 for moratorium on the use of death penalty. 108 countries have abolished death penalty. 8 countries have abolished death penalty for ordinary crimes. 28 countries have abolished death penalty in practice for execution for at least 10 years. 55 countries retain death penalty. By the end of 2021, 488 prisoners were on death row in India under serious offence, with introduction or proposal of more laws with death penalty, such as Punjab and Madhya Pradesh introduced death penalty for causing death by superious liquor. In 1980, in Bachchan Singh versus State of Punjab, the Supreme Court judges upheld the constitutional validity of death penalty due to built-in responsible procedural safeguards and its procedure, which is either arbitrary nor gives excessive discretion to judges. However, it gave a framework for future sentencing judges when deciding between the life imprisonment and death sentence. Even after 40 years of the judgment, the framework remains subjective and is often misrepresented. Arguments supporting death penalty. Deterrence. Death penalty is justified by its proponents for the great utility of the society as it has a brutalization effect, thus creating significant deterrence. Example, in Japan, approximately 3 prisoners are executed per year to reinforce the belief of bad things happens to those who do wrong. Retributive justice. Capital punishment is just a form of retribution, as people guilty of associated crimes deserve to be punished. As John Locke said, if someone violates violates others' right to life, they forfeit their own right to life. Death penalty brings a sense of psychological closure to the family and loved ones of the victim. Principle of proportionality. Justice demands that the punishment amount merited should be proportional to the seriousness of the offense. Will of the citizen. It is supported by the vast majority of citizens. Example, in 2012, a survey found that nearly 70% of Indians favored capital punishment continuance. Incentive to help police. Fear of capital punishment incentivizes prisoners on death row to help police to get reduced sentences. That is plea bargaining. Ethical issues with death penalty. Non-statistical proof of death penalty as biggest deterrent or more effective deterrent than less severe punishment such as life imprisonment. Non-constitutional value of redistribution. In a civilized society, as death penalty represents an eye for an eye, that is vengeance rather than retribution. Also, lack of supporting evidence on the psychological closure, or as families often react differently to different situations. Morality of death penalty is questionable as it outcasts the guilty below the status of man and citizen. It is against human dignity and violative of the inalienable right to life, even of those who are on the other side of the law. Supporting death penalty on grounds that it helps police in Origin, as similar argument can be used to justify torture, privacy violation, and other unethical practices. The restorative and rehabilitative aspect of justice get sidelined when law and order is approached from the perspective of retributive justice. For instance, with increase in education and socio-economic conditions of people, even serious crimes decline. Since 1992, India has been continuous decline in the murder rate from 4.2 per lakh of population to 2.7 per lakh of population in 2013. Other issues in death penalty, that their lack of objectivity due to no concrete framework on aggravating and mitigating factors. Second one, lack of procedural fairness due to discretionary interpretation of the rarest of rare cases. Lack of integrity, as media pressure often dictates the community's collective conscience. Adverse criminal justice system with structural and systematic issues such as lack of resources, ineffective prosecution, etc. Long delays faced by death row prisoners in trials, appeals, and thereafter in executive clemency. Mercy plea or clemency petition. For a person convicted by courts, mercy plea is the last constitutional resort. Under Article 72 of the Constitution, the President is empowered to grant pardon, etc., and to suspend, remand, or commute sentence in certain cases. It extends to cases of court martial, death sentence, or matter to which executive powers of the Union extends. He is bound to act on the aid and advice of the Council of Ministers. Similarly, under Article 161, the governor is empowered to grant pardons and to suspend the remit or commute sentence in certain cases. It extends to persons convicted of any offence against any law relating to the matter to which the executive powers of the state extends. He or she is bound to act on the aid and advice of the state government. Why do we need mercy petition? Mercy petition adds a human touch to the judicial process as punishment can be reviewed beyond the legal angle. It can help in saving innocent persons from punishment due to miscarriage of justice or in case of doubtful conviction. Miscarriage of justice, doubtful conviction can happen due to prevalent crisis in our criminal justice system because of issues such as torture, fabrication of evidence, poor legal aid, etc. Issue with mercy petition. No fixed time frame to act on the mercy plea leading to long delays. The Law Commission has highlighted certain precedents who put brakes on the disposal of mercy petition. Lack of transparency, as there is no compulsion to share uh, reasons for rejection or acceptance of mercy plea, but it is subjected to limited judicial review. Way forward principles to be adhered in ethical implementation of death penalty. Death penalty is an extraordinary expression of state demanding trust and transparency in its use. The recent guidelines from Supreme Court on proper consideration of mitigating circumstances of accused facing death penalty at the trial stage itself is a step to bring procedural fairness and objectivity while applying Bachchan Singh test. At the same time, the state must work on progressive development of human rights to ensure human dignity and to serve the case serve the cause of fair justice by resolving the issue of law ailing criminal justice system to avoid any miscarriage or failure of justice system. For instance, providing a competent defendant with resource, time, and skill to avoid arbitrary and capricious, capricious imposition of death penalty. Consistent judicial approach with due consideration of the restorative and rehabilitative aspect of justice to avoid any grave cost of imposition of death penalty, providing compelling justification for death penalty to avoid excessive punishment and maintaining the utmost respect for the value of life, ensuring that the mercy petition act as final bulwark against miscarriage of justice with time bound disposal to avoid the agony of uncertainty. Sedition. Next topic, sedition. Recently, Supreme Court has ordered that the 152-year-old sedition law under Section 124A of IPC should be effectively kept in abeyance till the Union government reconsiders the provision. About sedition. Indian Penal Code defines sedition as an offence committed when any person by words or otherwise brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law in India by words, either spoken or written, signs, visible representation, or otherwise. Three explanations added to the provision prescribed that while disaffection shall include disloyalty and all feeling of enmity, comments without exciting or attempting to excite hatred, contempt, or disaffection will not constitute an offense. Sedition is a cognizable, non bailable, and non compoundable offense under the law, entailing life imprisonment as maximum punishment with or without a fine. A person charged under this law is barred from a government job. They have to live without their passport and must produce themselves in the court at all times as and when required. In 2018, Law Commission of India published a consultation paper recommending that it is the time to rethink or repeal the section 124A of IPC that deals with sedition. Let us know about the background of sedition law. In 1837, British historian politician Thomas Macaulay drafted the sedition law as an offence punishable with life imprisonment. In 1860, sedition was omitted when IPC enacted. In 1870, Section 124A inserted in IPC by an amendment introduced by Sir James Stephen when it felt the need for the specific section to deal with the offence. 1831. First case registered when Jogendra Chandra Bose, editor of newspaper Bhangobashi, was booked for publishing an article criticizing age of consent bill. 1921. Bal Gangadhar Tilak, Annie Besant, Ali Brothers, Maulana Azad, M.K. Gandhi, and many others suffered imprisonment. 1848. Indian leaders agreed to drop sedition from Indian Constitution. 1948. 1948. Indian leaders agreed to drop sedition from Indian Constitution. 1949. Sedition is no longer part of Indian Constitution. However, Section 124A remains in IPC. 1951. Nehru government brings in First Amendment under Article 19(1)A and puts in reasonable restriction on right to free speech. 1962. In Kedarnath verdict, Constitution bench uphold the validity of sedition law. 1974, Indira Gandhi government made Section 124A cognizable offence that authorizes police to make arrest without a warrant. Next, significance of sedition law. Unity of India. Section 124A of IPC has its unity in combating anti-national, secessionist and terrorist element. So, so, stable polity. It protects the elected government from attempts to overthrow the government with violence and illegal means. The continued existence of the government established by law is an essential condition of the stability of the state. Many districts in the state face a moist insurgency and rebel groups openly advocating the overthrow of the state government by revolution. Powers of contempt. It is in line with the power of contempt according to court to protect its dignity. Similarly, contempt of government should also attract punishment. Public order. To maintain public order and to deter practices like civil war, excite dissatisfaction, to create public disturbance and to protect sovereignty of the country. Supreme Court stand on sedition law. Kedarnath versus State of Bihar 1962. Supreme Court held that a citizen has a right to say or write whatever he likes about the government or its measures by way to criticism or comment long as he does not incite people to violence. P. Alvi versus State of Kerala in 1982. Supreme Court held that sloganeering, criticizing of parliament or judicial setup did not amount to sedition. Issues associated with sedition law violate fundamental rights. The existence of Section 124A of the IPC has acted as a constraint on the exercise of the freedom of speech and expression guaranteed under Article 91, and governments have used sedition to suppress and quell political dissent. Ambiguity. The terms bring into hatred or contempt or attempt to excite disaffection can be interpreted in many ways, thus empowering the police and government to harass innocent citizens. Low conviction rate. As per National Crime Records Bureau data, between 2016 and 19, number of sedition cases rose by 160% to 93, but in 2019 the conviction rate in such cases was a mere 3.3%, which means just 2 of the accused were convicted. Misuse. There have been many instances of misuse of Section 124A where the government has used the sedition law to suppress protesting voices to protect its interests. For instance, the arrest of journalist Vinod Dao for criticizing the government's response to COVID-19 violate international agreement. The International Covenant on Civil and Political Rights (ICCPR), which establishes internationally accepted norms for the protection of freedom of expression, was ratified by India, and the misuse of Section 124A goes against this. Way forward. Clear definition. The term disaffection brings into hatred, and what constitutes a sedition should be clearly defined to prevent misuse by authorities. Procedural safeguards. Adding procedural safeguards in Section 124A of the Code of Criminal Procedures or through policy guidelines. For instance, the offences should be made non-cognizable so that there is at least a judicial check. Use sparingly. As per LCI, Section 124A should be invoked only in cases whether the intention behind any act is to disturb public order or to overthrow the government with violence and illegal means. Scrutinizing complaints, distinct and criticism are essential ingredients to robust and vibrant democracy. Therefore, every restriction on speech and expression must be carefully scrutinized to avoid unwarranted restriction. Sedition law in other countries. Many democratic countries, including United Kingdom, Ireland, Australia, Canada, Ghana, Nigeria, and Uganda, have held sedition law as undemocratic and undesirable and unnecessary. UK sedition law became obsolete in the 1960s and was finally repealed in 2009. However, sedition by an alien resident but not a national of the country is still an offense. USA, some sedition laws have been repealed or made a dead letter. The court provides a wide protection to free speech. Australia repealed its sedition law in 2010. Next topic, Supreme Court to have full strength of 34 judges. Supreme Court of India will have all sanctioned seats filled, that is 34 after more than 2 years. At present, Supreme Court has a strength of 32 judges as against the sanctioned strength of 34 judges. As per Article 124(1) of the Constitution of India, Parliament by law prescribes the strength of the Supreme Court. Appointment of judges. Chief Justice of India and the judges of Supreme Court are appointed by President under Article 124(1) of the Constitution with the help of collegium system. The collegium system has evolved with the three-judge case. First judge case 1981 or S.P. Gupta case. The Supreme Court ruled that recommendations made by Chief Justice of India to President can be refused for cognate reasons, thereby giving greater say to executive. Second judge case 1993 Supreme Court advocates on record association versus Union of India. Supreme Chief Justice of India only needed to consult two senior most judges over judicial appointments and transfer. Third judge case 1998 Chief Justice of India should consult with four senior most Supreme Court judges to form his opinion on the judicial appointments and transfers. Collegium is a system where a committee of Chief Justice of India, four senior judges of Supreme Court, and three members of High Court in case of appointment of High Courts take decision related to appointment and transfer of judges in Supreme Court and High Courts. Next, Presidential Poll 2022. Value of vote of Member of Parliament is likely to go down to 700 from 708 in presidential poll due to the absence of legislative assembly in Jammu and Kashmir. Value of vote of an MP in a presidential election is based on the number of elected members in legislative assembly of state and union territories including Delhi, Puducherry and Jammu and Kashmir. Value of vote has been fixed to 708 since the 1997 presidential election. For the first presidential election in 1992, it was 494. It increased marginally to 496 in 1957, and presidential election followed by 493 in 1962, 576 in 1967 and 1969. Next topic, Interstate Council. The central government has reconstituted Interstate Council. President under Article 263 can establish such a council and also authorize to define the nature of duties to be performed by such a council. In pursuance of the recommendations of Sarkaria Commission, Interstate Council was constituted in 1990. Interstate Council is a recommendatory body on issues relating to interstate, central state and central union territories relation. Composition. Prime Minister will be the chairman and chief minister of all states and 6 union ministers as members. Chief Minister of UTs having legislative assemblies and administrators of UTs not having legislative assembly are also its members. Union Home Minister will be a chairman of the standing committee. Next, Thiruvananthapuram Declaration. The first National Women Legislatures Conference in Kerala concluded with the adoption of Thiruvananthapuram Declaration. The Thiruvananthapuram Declaration laments the long pending women's reservation bill since 1996 for 33% reservation for women in Lok Sabha and state legislature. The low representation of women in parliament, that is lack of political empowerment in the main is the main reason for the India's poor performance on global gender gap published by World Economic Forum. India was ranked 140 out of 156 countries in 2021. Jammu and Kashmir delimitation exercise concludes as panel signs final order. The Delimitation Commission was set up on March 6, 2020 to redraw the boundaries of assemblies and parliamentary constituency in Jammu and Kashmir. The panel formed by the Centre in March 2020 is headed by former Supreme Court Judge Rajana Prakash Desai. The commission was proposed increasing the number of seats in the UTs from 83 to 90. Besides, there are 24 seats in Pakistan occupied Kashmir that continue to remain vacant. Delimitation is the act of redrawing boundaries of Lok Sabha and Assembly seats to represent changes in the population. Objective is to provide equal representation for equal population segment and fair division of geographical areas so that no political party has an advantage. Under Article 82, Parliament enacts a Delimitation Act after every census which established Delimitation Commission. In India, such DCs have been constituted in 1952, 1963, 73 and 2002. In 2002, 84th Constitutional Amendment was used to freeze the process of delimitation for Lok Sabha and state assemblies till at least 2026. Under Article 170, states also get divided into territorial constituencies as per Delimitation Act after every census. Article 170 deals with the composition of the legislative assemblies. Delimitation Commission is appointed by President of India and works in collaboration with the Election Commission of India. Its orders have the force of law and cannot be called in question before any court. Next topic, Places of Worship Act 1991. It prohibits conversion of any place of worship and to provide for the maintenance of religious character of any place of worship as it existed on the 15th day of August 1947. However, the provision of the Act shall not apply to the Ram Janmabhoomi Babri Masjid case. Act bars conversion of the place of worship of any religious denomination into place of worship of the different religious denominations. It further provided that such cases already pending at the court would stand abated. Next, government flagged low score in World Bank's worldwide governance indicators. In an analysis by the World Bank's worldwide governance indicator, a key input for India's sovereign rating, India scores very much below its peer on all counts. These data sources include the think tanks, survey agencies, and international media such as Freedom House, Economist Intelligence Unit, etc., which can lead to downgrading the sovereign rating. About Worldwide Governance Indicator. Worldwide Governance Indicator reports aggregate an individual governance indicator for over 200 countries and territories over the period of 1996 to 2020. It is based on 6 dimensions of governance, combining views of a large number of enterprises, citizens, and expert survey respondents in industrial and developing countries. Earlier, other reports were also flagged for such downgrading, like World Health Organization a methodology to estimate COVID-19 mortalities. Economic Intelligence Unit showed India's rank fell from 27 in 2014 to 51 in 2019, and Global Hunger Index 2021, which ranked India at the 101st position out of 116 countries. Such methodologies have an issue like over weightage or to a particular indicator using inappropriate statistical mathematical model, comparison of the past performance of a country without incorporating significant inputs, use of a subjective approach to qualify other objective measures, etc. Next, World Press Freedom Index 2022, released by Reporters Without Borders or a non-profit organization. Index highlighted degree of freedom that journalists, news organizations, and netizens have in each country, and governments effort to respect such freedom. Ranking are based on scoring ranges from 0 to 100, with 100 being the best possible score, highest possible level of press freedom, and 0 the worst. Evaluation criteria include 5 indicators: political context, legal framework, economic context, socio-cultural context, and safety. India recently slipped 8 places to 150 in 2022 World Press Freedom Index, from last year's 142nd rank out of 180 countries. Next, the next class which shall study about international relations. Thank you.